Over a week after Jack Smith filed the immunity brief, we finally have a redacted version of it. So I'm going to try and provide a concise summary of 180 pages. Welcome to Law and Society. Please subscribe and let's dive into it. So this episode is going to be a little bit longer, obviously, because I'm going to go over the immunity brief. But I want to start out by saying that this brief is so long simply because Jack Smith and the DOJ had to reiterate the facts of the case that's part of the superseding indictment. Then it had to present what the law is and how it has read Trump the United States and how immunity should apply. Then Jack Smith goes ahead and applies the law to the facts to say how and why the presumption of immunity is rebutted in every instance. So, what I'm going to do is I won't go back and read you excerpts from the factual findings because the factual findings are the same as they were in the superseding indictment. What I want to do is I want to go back and remind you about what the test was as applied by the Supreme Court, and then go into how the government presents its legal analysis of why the acts presented in the charge document are unofficial acts, or if there's a presumption of immunity, how they are rebutted. Here we go with the legal framework. In Trump the United States, the Supreme Court held that former presidents are immune from prosecution for core official acts, enjoy at least a rebuttable presumption of immunity for other official acts, and no immunity for unofficial acts, and remanded to this court, meaning Judge Chutkan's court, for further proceedings consistent with this holding. The Supreme Court divided the presidential acts into three categories: core presidential conduct that Congress has no power to regulate and for which a former president has absolute immunity. Two, the other official presidential acts for which the president has at least presumptive immunity that has to be rebutted. And third, unofficial conduct for which the president has no immunity. With respect to the first category of core official conduct, the president's authority to act is conclusive and preclusive. Congress may not regulate his actions, and the president has absolute immunity from criminal prosecution. Applying those principles to the original indictment, the Supreme Court concluded that the defendant is absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials and his threatened removal of acting attorney general. The Supreme Court did not find any other conduct alleged in the original indictment implicated conclusive and preclusive presidential authority. The threshold question here then is whether the defendant can carry the burden to establish that his acts were official and thus subject to presumptive immunity. Official conduct includes acts taken within the outer perimeters of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. But consistent with DC Circuit's opinion in Blasingame, the Supreme Court suggested that a president who speaks as candidate for office or party leader, as the defendant did here, does not act in his official presidential capacity. A president acting as a candidate for re-election is, to that extent, not carrying out an official responsibility. To assess whether a presidential action constitutes an official act, courts must apply an objective analysis that focuses on the content, form, and context of the conduct in question. A president's motives are for sorry, a president's motives for undertaking the conduct and the fact that the conduct is alleged to have violated a generally applicable law are not relevant considerations. If a president's actions constitute non core official presidential conduct, he is at least presumptively immune from criminal prosecution for that conduct. The government can overcome that presumptive immunity by demonstrating that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. Just as inquiry into whether conduct is official or unofficial is necessarily fact bound, with the necessary analysis being fact specific, so too should the inquiry into whether, so too should be the inquiry into whether any presumption of immunity is rebutted under the circumstances. The analysis should first identify the specific alleged act at issue and then determine whether criminal liability for the act intrudes on a relevant executive branch authority or function. Taken care not to conceive of the inquiry at too high a level of generality. So you have to look at the specific acts alleged to be able to see if there's criminal liability. You can't do a washover. Executive authority has limits, boundaries imposed by constitutional text and separation of powers and precedent. And the application of criminal law to the president's official conduct does not per se intrude impermissibly on executive branch authority and functions. The government may not introduce evidence of immunized official conduct against a former president at a trial, even to prove that the former president committed a crime predicated on unofficial conduct. So, this is what the premise is set. This is the law that the Supreme Court has given, and this is how the government has been able to synthesize the ruling of Trump v. United States into saying, how do we navigate through the charges that have been brought against Donald Trump, given the Trump v. United States premises for liability and then immunity. So in section 3 of the government's, so that was section 2. That's really quick because that's about the law at hand. And then there's a longer section, section 3, that goes into talking about how none of the allegations or evidence is protected by presidential immunity. At its core, the defendant's scheme was a private one. He used private actors and his campaign infrastructure and operated in a private capacity as a candidate for office. To the limited extent that the superseding indictment and proffered evidence reflect official conduct, however, the government can rebut the presumption of immunity because relying on that conduct in this prosecution will not pose a danger of intrusion on the authority or functions of the executive branch. Below, the government categorizes the conduct outlined in section 1 and provides context, form, and content for this court to determine that the defendant's conduct was private, or that in the alternative, any presumptive immunity is rebutted under the circumstances. This section first addresses the defendant's interactions with Pence, because in Trump v. United States, the Supreme Court held that when the defendant conversed with Pence about their official responsibilities, the conduct was official. Accordingly, the government explains below why any presumptive immunity as to the defendant's official conduct regarding Pence is rebutted. This section categorizes that conduct provided. This section, let me start over. This section categorizes that conduct and provides the content, form, and context that establishes its unofficial nature. These categories are the defendant's interactions as a candidate with state officials, the defendant's effort as a candidate to organize fraudulent electors, the defendant's public speeches, tweets, and other public statements as candidate, the defendant's interactions as a candidate with White House staff, and other evidence of the defendant's knowledge and intent. Then Jack Smith goes into the defendant's interactions with Mike Pence. This is the biggest chunk of the brief, because this is the part where the government is addressing the explicit instruction and ruling of Trump United States and scrutinizing on the role of the vice president and saying, we're going to now see whether the conversations between Pence and Donald were immune or not. The only conduct alleged in the original indictment that the Supreme Court held was official and subject to at least rebuttable presumption of immunity was the defendant's attempts to lie to and pressure Vice President Pence to misuse his role as president of the Senate at congressional certification. Whether the government can rebut the presumption of immunity that the Supreme Court held applies to such conversations is the question. Because the executive branch has no role in certification proceedings, and indeed, the president was purposely excluded from it by design, prosecuting the defendant for his corrupt efforts regarding Pence poses no danger to the executive branch's authority or functioning. The government also intends to introduce at trial evidence regarding conversations between defendant and Pence in which they did not discuss Pence's official responsibilities as president of the Senate and instead acted in their private capacities as running mates. And the government intends to elicit that trial evidence about a Pence staffer's conversation with co-conspirator 2. Those conversations were unofficial and therefore not immune. The defendant's interactions with Pence as the president of the Senate were official, but the rebuttable presumption of immunity is overcome. The superseding indictment and the government's trial evidence include the defendant's attempt to influence Pence's oversight of the certification proceedings in his capacity as president of the Senate. The Supreme Court held that discussions between the defendant and Pence concerning Pence's role at the certification proceeding qualify as official conduct and therefore are subject to a rebuttable presumption of immunity because they involve the president and the vice president discussing their official responsibilities. Those discussions qualify as official because presiding over January 6th certification proceeding at which members of Congress count the electoral votes is a constitutional and statutory duty of the vice president. The discussions at issue did not pertain to Pence's role as president of the Senate writ large, however, but instead focused only on his discrete duties in presiding over the certification proceeding, a process in which the executive branch by design plays no direct role. We'll see Jack Smith reiterate that in these proceedings, when talking to Mike Pence about the certification proceedings, the executive branch does not have any role in that. A prosecution involving the defendant's efforts to influence Pence in the discharge of this particular duty housed in the legislative branch would not pose any dangers of intrusion on the authority and functions of the executive branch. The executive branch has no authority or function to choose the next president. To the contrary, the Constitution provides that states will appoint electors to vote for the president and vice president. That's according to the United States Constitution, Article 2, Section 1, Clause 2. And all states have chosen to make such appointments based on ballots cast by the people in their respective states. Congress may determine the time of choosing the electors and the day on which they shall give their votes. But the executive branch has no direct role in that process. The next step in the process established by the Constitution similarly provides no role for the executive branch. The House and Senate meet in joint session with the President of the Senate present to open all the certificates of the state appointed electors in the presence of the House and Senate for them to be counted. If only state appointed electors have failed to make a choice, no candidate has such a majority, does the choice fall on the House of Representatives. There, too, the executive branch plays no role in the process. The exclusion of the executive branch reflects fundamental constitutional principles. This section is important to understand. The executive power is vested in a president for a term of 4 years, and it transfers to its successor by operation of law at noon on the 20th day of January. That's according to the Constitutional Amendment 20. Permitting the incumbent president to choose his own successor, or worse still, to perpetuate himself in power, would contradict the entire constitutional system that the framers created. In free governments, Benjamin Franklin explained, the rulers are the servants and the people their superiors and sovereigns. Thus, while the framers recognized the necessity of an energetic executive, they justified and checked his power by ensuring that he always retained a due dependence on the people. Some of those precautions are reflected in the design of the Electoral College itself. Wary of cabal, intrigue, and corruption, the framers specifically excluded from service as electors all those who from situation might be suspected too great devotion to the president in office. They were keenly aware, as Justice Story later explained, that an ambitious candidate could hold out the rewards of office or other sources of patronage in an effort to influence a majority of votes, and thus, by his own bold and unprincipled conduct, to secure a choice to the exclusion of the highest and purest and most enlightened men in the country. To guard against that possibility, Article 2 provides that no senator, nor representative, or person holding an office of trust or profit under the United States shall be appointed as elector. So this is explaining with helpful context from the Federalist Papers and the Constitution, the constitutional principles that undergird the importance of separating the executive branch from this function of certifying the votes. These limitations serve to prevent the person in office at the time of the election from having any improper influence on his re-election by his ordinary agency in the government. The Constitution reflects an abiding concern that governmental power is of an encroaching nature and that it ought to be effectually restrained from passing the limits assigned to it, not least to protect against the danger to liberty from the overgrown and all-grasping prerogative of an hereditary magistrate. So essentially saying a king, like an all-powerful king. We don't want that. Framers therefore designed a system of separated powers in part to ensure that no man is allowed to be a judge in his own cause, because his interest would certainly bias his judgment and not improbably corrupt his integrity. He sought to, so now we go, the defendant's charged conduct directly contravenes these foundational principles. He sought to encroach on powers specifically assigned by the Constitution to other branches to advance his own self-interest and perpetuate himself in power contrary to the will of the people. As such, applying a criminal prohibition to the defendant's conduct would not pose any danger of intrusion on the authority and functions of the executive branch. Rather, it would advance the Constitution's structural design to prevent one branch from usurping or impairing the performance of the constitutional responsibilities of another branch. As President Lincoln explained in 1864, by the Constitution and laws, the president is charged with no duty in the conduct of a presidential election in any state. And if any election shall be held and any vote shall be cast in the state of Tennessee for president and vice president, it will belong not to the military agents nor yet to the executive department, but exclusively to another department of the government to determine whether they are entitled to be counted in conformity with the Constitution and laws of the United States. So we see here the President Lincoln setting this precedent that no, the president is not charged with the duty of presidential elections. So we have to harken back to those days and find reason in saying that no, our system of government and our constitutional principles forbid a sitting president from getting anywhere near the certification proceedings or the ballot or the accounting of the ballots or anything to do with election. The government is aware of no contrary evidence, including of any president other than the defendant, seeking to influence his vice president in the discharge of his duties as president of the Senate in presiding over the joint session. When it comes to the certification proceedings specifically, not only has the president been deliberately excluded from the process, but the vice president's role as president of the Senate is highly circumscribed and ministerial in nature. Removing any possible doubt, Congress has legislated extensively to define the vice president's role in counting the electoral votes. And it has never provided any substantive role for the vice president, instead assigning the resolution of disputes to the two houses of Congress. Moreover, Congress has now made explicit, echoing and reaffirming constitutional tradition and practice, that with limited exceptions of no relevance to this case, the role of the president of the Senate while presiding over the joint session shall be limited to performing solely ministerial duties. Because the vice president's role is and has always been ministerial rather than substantive or discretionary, it is difficult to imagine an occasion in which a president would have any valid reason to try to influence it. As such, criminalizing a president's effort to affect a vice president's role as the president of the Senate overseeing the certification of the Electoral College results would not jeopardize an executive branch function or authority. So there's nothing that is part of executive branch function and authority that is implicated in the superseding indictment in this case. Critically, applying the criminal prohibition to a discrete and distinctive category of official interactions between president and vice president alleged in this case would have no effect, chilling or otherwise, on the president's other interactions with the vice president that implicate executive branch interests. The president would still be free to direct the vice president to discharge his executive branch functions of diplomacy, of negotiation, to be able to advance the president's agenda in Congress, cast the tie-breaking votes. None of those legitimate executive branch functions of the vice president are chilled or affected at all by this prosecution. Although the White House counsel was invited, so now we go into certain parts of it where there were conversations with Pence in which White House counsel was brought in. Although White House counsel was invited to the meeting, when he arrived to attend, the defendant explicitly excluded him from it, meaning that the only attorney attending the meeting for the defendant was co-conspirator 2 in his privately retained counsel. In the Oval Office meeting, the defendant said words indicating that he did not want me in the meeting. That's what the White House counsel says. It is hard to imagine stronger evidence that conduct is private, that when the president excludes his White House counsel and only wishes to have his private counsel present. The defendant's decision to include private actors in the conversations with Pence about his role in certification makes even more clear that there is no danger to the executive branch's functions and authority, because co-conspirator 2 conversations had no bearing on the executive branch's prerogative. Instead, all his conduct objectively benefited the defendant in his private capacity as candidate. At trial, the government intends to introduce evidence of private phone calls or in-person meetings that the defendant had with Pence in their official capacities as running mates. These conversations were not described in the original indictment, nor analyzed by the Supreme Court in its opinion, nor are they described in the superseding indictment. In these conversations, the defendant and Pence discussed their electoral prospects, election-related litigation, and possibility of the defendant running again in 2024 if his legal challenges failed. They were frank exchanges between two candidates on a shared ticket, and the government does not intend to elicit testimony about any peripheral discussion of arguably official responsibilities. A president acts in a private, unofficial capacity when engaged in re-election campaign activity. Together, these discussions show that defendant and Pence considered advice from their shared campaign advisors, weighing electoral strategies and grappling their loss. Both men had something to gain by winning the re-election, making more notable the persistence of Pence's suggestions on how to accept the results of the election without losing face. Even if the court determines that these conversations were official, however, the government can rebut the presumption of immunity because the use of this evidence poses no risk to executive branch prerogatives. The content of the conversation at issue has no bearing on any function of the executive branch. Pence staffer, person 58, also participated in a January 5th meeting with co-conspirator 2. These interactions were outside of the defendant's presence, and the latter was a series of emails. These conversations are not official within the meaning of Trump v. United States, since the defendant was not involved and did not otherwise direct those actions. And because of the other information above describing co-conspirator 2's inherently private role. So I think co-conspirator 2 would be Eastman, I think. I haven't read any of the other people talking about this case. I sort of shut myself off to all of that just to be able to read this brief. So thank you so much for being here. It has now been half an hour. I'm going to keep on reading, and it's getting dark because it's raining really heavily here, and I use natural light. I don't have any sort of fancy lighting or anything, so please pardon the darkness. Hopefully, it will get a little bit more light in a little while. So, with that said, let's go on. Let's continue. The defendant's interactions in his capacity as a candidate with officials in targeted states. The defendant, in his capacity as a candidate, contacted state elected officials to use false claims of election fraud to induce their assistance with charged conspiracies at the point in the electoral process in which states ascertain electors. So then we go into how this section goes into how Donald Trump's actions were him working as a candidate. There was no official executive role that the executive branch has to play in how states determine election matters. In each conversation, the defendant raised false claims of election fraud when pressing state officials. And in each case, the state officials informed the defendant that they had not seen fraud he was claiming had occurred in their state. So, most importantly, as with the defendant's plan regarding the fraudulent elector slates, as president, he had no official role in the process by which states appointed and ascertained their presidential electors. Here, Jack Smith brings back Justice Barrett's concurring opinion, in which Justice Barrett in Trump v. United States said that the president has no authority over state legislatures or their leadership, so it is hard to see how prosecuting him for crimes committed when dealing with Arizona House Speaker would unconstitutionally intrude on executive power. The content, form, and context of defendants' interactions in these state officials firmly established that his conduct was unofficial. So Jack Smith goes on with calls made to other people, with meetings with Michigan legislators, in all of which where Donald Trump was operating in his capacity as a candidate, and he had no constitutional authority to go and essentially threaten and blackmail state officials into changing the votes, like he tried to do with Georgia and Arizona, and it was less obvious in the other states, but he also tried it in Michigan and Pennsylvania and Nevada. So all of these, they all are part of Donald Trump trying to win the election and going to these people as a candidate and not as president in his official capacities, because the president does not have, the executive branch does not have any authority over elections, over management of elections. So, it's an exhaustive list of how in each instance the defendant was dealing in his personal and private capacity. The defendant's interest in a case that was brought to the Supreme Court was personal and private. The lawsuit dealt only with elections of the offices of president and vice president, not the myriad other races on the same ballots. Indeed, the day after his call, the defendant, with person 26, the defendant, in his personal capacity and with the assistance of co-conspirator 2 as his private attorney, intervened in a lawsuit, and in doing so, affirmatively communicated to the Supreme Court and the public that he was acting and speaking in a matter in his personal capacity as candidate for re-election. So here, sort of, Jack Smith brings up that, he himself is saying that he was candidate in lawsuits that he brought, but he is unwilling to concede that these acts are not immune. I'm going to go and read a few more excerpts, especially since it's getting so dark, and sort of, it's every section, in every conversation that he had with whether it be Kenneth Chesbrough, whether it be the blackmailing Rusty Bowers from Arizona, whether it be blackmailing Raffensperger, those instances, those are all him going to these officials in his private capacity as a candidate. So even if the defendant's contact with state officials were official, the government can rebut the presumption of immunity. Indeed, the Constitution commits to states the power to appoint presidential electors in manner as the legislature thereof may direct. The president, meanwhile, plays no direct role in the process, nor does he have authority to control the state officials who do. And the framers, wary of cabal, intrigue, and corruption, specifically excluded from service as electors all those who, from situation, might be suspected of too great devotion to the president in office. So you see, it comes up over and over again. These Federalist Papers that talk about circumscribing the power of the presidency, and how certain acts like elections, the president does not have any official duty. This case does not remotely implicate official conduct. What neither the president nor other candidates may do is further his private campaign for office by using fraudulent means to have state officials certify him as winner of a presidential election, despite the will of the voters. Accordingly, applying criminal penalties to that conduct will not intrude on any executive branch authority or function. The President of the United States has no official responsibilities relating to the organization or voting of electors in the various states by virtue of the Constitution. And that process takes place in the states according to the laws and procedures set forth by each state. It's as simple as that, and it is repeated over and over and over in this brief to reiterate how this conduct is unofficial, how it was him working in his capacity as a candidate. So on and on we go. Thank you for being here. I am doing my best to be able to give you a gist of this brief. So essentially, DOJ goes through every single thing that they intend on bringing up, whether it be his public speeches, his tweets, his public statements, his interactions with the different people, from Rusty Bowers to Brad Raffensperger, his speeches in Dalton, Georgia, and then in the Ellipse. The RNC paid for the event in Dalton, Georgia. So it wasn't him in his official capacity as president. It was him as a Republican candidate. When he was going to Georgia, the trip binder included a Hatch Act disclaimer stating that employees of the federal government may not use their official title or position when participating in a political event. It was because Donald Trump was going down to Georgia to support and talk about the two runoff elections in Georgia Senate that Democrats ended up winning. So one was won by Raphael Warnock, the other one by Ossoff. So it matters here that the description of the event which the defendant was traveling was remarks at a rally, at a victory rally. This nomenclature, the use of the phrase victory rally, is significant. Victory necessitates one political candidate or party defeating another, and rallies are the kinds of events that candidates hold to excite their supporters and garner votes. So Donald Trump talked about the radical left, talked about winning big, talked about the election of retaining Republican Senate majority, and it was an election event in which he went and talked, not in his official capacity as president, but in his capacity as a campaigner and the leader of his party. A campaigner and leader of a political party does not have immunity from prosecution. So then continuing onward, then we go on to the rally that happened on January 6th. The Ellipse rally was originally planned to take place at Freedom Plaza and it was organized by Women for America First. But after the organization began to plan the rally, independent of the defendant, private fundraiser for the defendant contacted the organization to discuss moving the event to the Ellipse and featuring the defendant as a guest. The Secret Service considered the rally to be a campaign event, and the rally was completely funded by the grocery chain heirs of Publix. The private funding, while not dispositive, is a strong indicator that the event was unofficial. The rally organizer, who had the most direct contact with the defendant, was an employee of the defendant's campaign until December 31st, when he became a private citizen. And public statements since leaving office, the defendant has said repeatedly that he had nothing to do with the rally other than they asked me to make a speech. I showed up for a speech. So, using Donald's words against him here. And saying that, yeah, he himself said that he's going there for a rally and a speech. He had nothing else to do with it. It wasn't a White House affair. It wasn't an official statement that he was giving to the people in his capacity as president of the United States. So the defendant's White House employees understood the rally and the defendant's speech to be a private, unofficial exercise and acted accordingly. And officials in the White House counsel's office, who customarily review the defendant's official remarks, pointedly did not review the Ellipse speech because it was an unofficial campaign speech. So there are many ways in which Jack Smith puts the case in front of Judge Chutkan in showing how these actions by Donald Trump were private actions. And as you go down, Jack Smith expounds on each of the cases, each of the rallies where Donald Trump implored to put political pressure on Mike Pence over and over again. And he went after Arizona, Georgia, lies about Arizona, lies about Georgia, lies about Ruby Freeman and Shane Moss, lies about Michigan, Nevada, Pennsylvania. They were all, he had rolled them all up, and he was lying during his speeches and talking about election matters. There was significantly, he made many of these statements at the beginning of the speech, framing the themes for the rest of the speech. Although countless state, federal, and local races were also on the same ballots as the defendant on election day, defendant focused only on his own race, the election for president, and only on allegations favoring him as a candidate in targeted states he lost. He framed the claims of election fraud in terms of his own election and margin of victory in his own race, and he spoke to his political supporters using the pronoun we, showing that he was speaking not to all citizens, but only to his own voters. Then it goes on to the tweets. So one of the tools that Donald Trump used, both official and unofficial, was his Twitter account. And the communications, just because he put official words sometimes in his personal Twitter account, does not make all of his acts and through Twitter doesn't make it official. Because if you look at Donald Trump's personal, private, real Donald Trump account, you'll see that he has used it since 2009. and he used it in his capacity as as a campaigner, and he did it again after the elections. So then Jack Smith goes into the Supreme Court's recent decision, confirms that a public official's personal social media account can be used for both personal and public business, and consistent with Trump v. United States, that is fact-specific inquiries required to discern which category a post falls. In conducting the necessary tweet-by-tweet analysis, context and content matters. Simply because a tweet relates to a matter of public concern does not automatically transform it into an official communication. So, and I'm sort of fast tracking through this now. Below, the government analyzes the content, form, and context of various categories of the defendant's tweets, and tweets making false claims of election fraud, tweets as candidate casting doubt on election integrity, tweets and retweets attacking those speaking truth about the election, tweets targeting Mike Pence, targeting the Philadelphia city commissioner, who then received several death threats because of those tweets. Targeting people in Detroit and Philadelphia, targeting people in Georgia and Pennsylvania. Those were tweets that attacked 4 Pennsylvania legislatures, and each of them were to harass and pressure these individuals into doing his bidding. They didn't follow his bidding, and so he went out and attacked them on Twitter. On December 21st, when Wisconsin governor signed a certificate of final determination confirming that Biden had won the state-based resolution by the Wisconsin Supreme Court of a lawsuit in Biden's favor, the defendant took to Twitter to attack the justice who had written the majority opinion that ruled against him. The defendant encouraged Republicans in Wisconsin to go to their state legislatures and overturn this ridiculous state election. We won in a landslide. The entire context of the defendant's tweet about person 49, which I think is Kemp, Governor Kemp, including his fictitious endorsement of person 49, his encouragement of Wisconsin Republicans to lobby their legislatures, and his claims to that end, we won, demonstrate that the tweet as a whole was partisan, personal, and official. So you have Jack Smith goes through every single tweet regarding Mike Pence, and then points out the fact that Donald Trump knew when he was sending out these tweets that Mike Pence would not budge. Mike Pence said it on that day at 11 o'clock before he went out to speak. Mike Pence told him that he wasn't going to follow through with what Donald Trump wanted. And so Donald Trump went after Mike Pence on Twitter. The context and content of these tweets established they are unofficial. Through the tweets, the defendant was using the political pressure of his supporters and social media followers to convince Pence to take an action to benefit the defendant as a candidate and help him overturn the results of the election. The private and campaign nature of the tweets further confirmed, when viewed in context of the defendant's increased desperation, as even his unlawful path to remain in power narrowed. So, him going after Mike Pence, when he tweeted on January 5th that Pence had the power to reject fraudulent electors, Pence had already told him many times that Pence did not believe he had such power. So, you see the corrupt intent over there. You just by looking at the facts, it's just laid bare in front of you that Mike Pence would not go along with Donald Trump, and that's why Donald Trump went after Mike Pence. And Jack Smith describes how, uh, you know, what Donald Trump was doing, and during the time that the Capitol was being breached. So the defendant told the crowd to act, stating, "We cannot let it happen," and then directed his supporters, who were angry and motivated by his speech, to march to the Capitol. Instead of marching with his supporters, as he said he would, the defendant returned to the White House. He went to the dining room next to the Oval Office and began to watch television coverage and events of the Capitol. Although the government does not intend to use at trial evidence of the defendant's discussions with White House staff during the period, it provides necessary context. I'd just like to say here that Jack Smith is kind of like pushing back here and saying that, you know, we are not using this. You know, it provides context, even though that we're not going to use what was said during what was said between his staff and him during this time that he was in the dining room next to the Oval Office watching the insurrection unfold. And Jack Smith does it by saying that it provides necessary context, which is necessary in terms of Trump v. United States. The defendant's advisors and Deputy White House counsel urged the defendant to issue calming message. The defendant refused, responding that the people were angry because the election had been stolen. It was at that point that the defendant issued the 224 tweet attacking Mike Pence. A minute later, Secret Service was forced to evacuate Pence to a secure location. So the close proximity of his words to what the people were doing, and then he sent out another tweet saying support our Capitol Police. And he's been watching the insurrection for over an hour now, because the insurrection started like around 1:12, I think, 1 o'clock, and then in an hour they were breached. The Capitol was breached. So after those tweets failed to disperse the rioters, he went on and sent a video saying, "You are very special people who love," that he loved, asked them to leave the Capitol, also claimed that we had an election that was stolen from us. So he sent a tweet conveying a similar sentiment at 6 p.m. after all of the essentially the insurrection had happened. These are the things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from the great patriots who have been badly and unfairly treated for so long. Go home with love and peace. Remember this day forever. It's kind of like, he's talking about in his private capacity, about his loss. And he wasn't talking about anything else other than in his earlier tweets, he wasn't talking about anything else other than Mike Pence and what to do with the election. And then at 2:40, 2:30, and then 4, he realized that nothing was going to happen, that he had lost. So he then came out with the generalized addressing the matter of public safety. And so there's no need to bring up those, because that falls under his official conduct. But it is important to point out in this brief the context in which Donald Trump was using those words. It is important to know the context. Let's see. So there were other public statements made, and goes through every single one and essentially says that none of the acts were official acts because they were private in nature. Even if you consider them official, this is why it's rebuttable, whether it be the Constitution telling you, or if it's Constitution and the Electoral Count Act and the Federalist Papers and constitutional principles telling you the president has no role in elections and certification proceedings. And therefore, he was acting in his capacity as campaigner, and he was electioneering, and he was threatening people in his private capacity. So, and because he was doing that in his capacity as a candidate and his capacity as a private individual and not the executive, Donald Trump is not immune from these actions. And this evidence, that this information that is in this brief, should be permitted to follow through into a trial that holds Donald Trump criminally liable for the acts that he committed to defraud the United States, to obstruct an official proceeding, and to defraud the people of their right to vote. So that's what this overarching brief is about. It is a compendium on what Donald Trump did. It is a comprehensive layout of the facts, then the law, and then how to apply the law to the facts. And I believe that now we have to wait and see what Donald Trump replies, and then Jack Smith will reply to that, because Jack Smith said that it is the defendant's job to prove that these actions were official. And once defendant does prove that these actions are immune because they were official, the government will reply with another brief. With that said, thank you so much for being here. Thank you, Deb, for being here. It's good to see you. And I will talk to you soon. Please like, share, and subscribe. That helps me out a lot. I'm cutting this short at an hour, and that's also too long, but I believe that I've grasped the middle, which is important here, which is the ruling of the Supreme Court, how Jack Smith synthesized that ruling, and how then he applied it to the facts to show that Donald Trump's actions were not immune because he was acting in his private capacity as candidate. So take care.